Welcome to the Oliva Gibbs Energy Education Series. Thanks for joining us today. This is part 2 of State versus Tribal Severance Taxes, Legal History and Recent Cases. Some of you were able to see part 1 last month. We respect your time at lunch, so we didn't want to go over, so we made this a 2-part. If you did not see it or had to leave early or just missed it, you can get onto our website and review part 1. And also you can look on our website for all future webinars and seminars that we are presenting. We do 1 or 2 free seminars every month, so we'd love to have you join us. Greg Harjo is my colleague here in Oklahoma City, and he has over 20 years experience of doing title and is our resident Indian expert. And my name is Chuck Lundeen, and I'm senior counsel for Oliva Gibbs, and I've got over 40 years experience as an oil and gas attorney and in-house landman. Welcome. We're excited to have you with us, and so I'll just go ahead and let Greg get started.
Thank you, Chuck. So today we're going to pick up where we left off. The last seminar we did, I believe we were just getting ready to discuss the Indian Child Welfare Act, which was enacted in 1978. But before we do that, for those who may have missed that first one, or just to get a refresher of what we covered the first time, we'll just go over really quickly some of the key points in order to understand where we're going. And then we're going to get into some important severance tax cases that discuss these issues. Definitions of Indian country, and that's just a key point to know when we're going to talk about any kind of regulation, tribal or state, and even federal regulation in this area. We need to know the technical terms and the legal terms, which is Indian country, and it's codified in Title 18 of the United States Code, Section 1151. For interest, you know, Chuck and I might use that term U.S.C, Section 1151, but you know, maybe some field landmen out there or landmen may not have a reference to that, but that's just United States Code 1151, which it's actually a criminal code, but it's actually where you find the definition of Indian country.
And Greg, this Indian country, it's really just a term of art, isn't it? I mean, it's synonymous with a reservation.
It is. It means all these things that it says right here, dependent Indian communities, you know, reservations. So basically tribal lands are synonymous with that. So you'll hear the term reservation, tribal lands, Indian lands, or Indian country, but the legal term of art to be used is Indian country.
And throughout the presentation, Greg's made it easy. Anything that is in green affects the Indians in a positive way, and anything in red is state issues.
Right. So then, for instance, on that particular statute, A there supports the tribe's definition of Indian country, and it just encompasses the entire reservation. Also within this particular slide, you'll see Section 1152, the General Crimes Act, and that is relevant because it discusses who's going to have jurisdiction in certain issues. Even though they're criminal, those types of authority are then brought over into the civil jurisdiction purposes. So when we talk about severance taxes, reference to this particular statute will be helpful to know. So, and we'll talk more about this. There's a major case on this 1152 called Castro-Huerta, foundation of the plenary power. Again, we covered this last time, but just going quickly.
Real quick before you go, for those of you who don't want to go look up what plenary power is, it's the idea that Congress has full authority over the tribes, and so I just wanted to.
Right, and this idea of plenary power, where does it come from? And I see I've listed out here the United States Constitution, Article 1, and sets forth all these things here, and I won't list them out, but you got them there. And this is where the plenary power comes from, this, and also from the treaties, which says that when the United States did treaties with the tribes, it was going to be subject to the what laws Congress may have upon you. So there's 2 sources there. And the question now, and you'll see in some of these cases we'll look at, is have we gone too far with the idea of plenary power? What's off the table? What's off the charts? Can Congress do whatever it wants with regards to Indians, or are there limits? Let me give you 2 examples real quick. Indian Gaming Regulatory Act, that's a 1988 act. And so all our casinos here in Oklahoma and all across the country in the Indian casinos are regulated under the Indian Gaming Regulatory. Well, that's considered well within Congress's power to do that. They have authority to, under the Indian Commerce Clause, to regulate that. What about the Indian Child Welfare Act? That's 1978 Act also, and we're going to talk about that. There's a major case going on right now that's contesting the constitutionality of that act. But you can just imagine, and there are many hypotheticals in these cases in the oral argument that the justices posed to the attorneys, saying what is too far? How far can Congress go? And honestly, the general thinking right now is that nothing is off the table for Congress. They, with the stroke of a pen, could eliminate the tribes. Now, whether that's accurate or not, I think we're going to find out with this next term, or the current term we're in. There's some cases that should be issued in June.
So a year from now, this may be a whole different presentation.
It's possible. There's a case right now, again, pending Bracker versus Holland. And again, we'll talk about that. And it definitely challenges the race nature of some of these statutes, whether it's based on race or whether it's based on political affiliation. So, of course, the tribes' argument is based on political affiliation. State's argument is based on race. So, but hopefully we'll have time to discuss those cases. Again, just going through some of these, and I'll go through them quickly. Worcester versus Georgia, we talked about that. And that's where basically the Supreme Court said that tribes have the right to exclude on their reservation. So if they have the right to exclude, then definitely they have the right to tax. And so,
well,
no. So the point being is where the tribes get the right to tax, and again, it's from many things, but this case in particular, if you have the right to exclude, you have the right to tax. Now there'll be some cases we look at where the tribes no longer have the power to exclude, but do they retain the power to tax? And we'll hopefully address that question.
So this is really the first big case in support of the Indians.
One of the first major cases, it's called the Marshall Trilogy. And with these and the other two were the first three major cases. And this one really stood for the tribes' rights to exclude those from the territory, and self-government is what the case stood for. Go to skipping forward then to slide 21, I believe we're there. Treaty of June 14th, 1866. This is the most recent treaty for the Muskogee Creek Nation. And so again, in red here, favoring the states because the Creeks agreed to the legislation as Congress and the President of the United States may deem necessary for their better administration of judgment or justice and the protection of the rights of persons and property within their territory. Now that can be read very broadly, right? Mm-hmm. So with that alone, if you read that broadly, then Congress can do whatever it wants, okay? But the very next sentence favors the tribe. Provided, however, said legislation shall not in any manner interfere with or annul their present tribal organization, rights, laws, privileges, and customs. So there's a balancing act, right? And what you'll see as we look through these cases, it's just one balancing act after another. Otherwise, I could begin this presentation with just telling you, here's the law regarding taxation, tribal and state taxation. In one sentence, I'll be done with it. But honestly, it's going to be a balancing test, case by case by case.
In the Creeks, when they ceded the acreage, they did get money for it.
Right.
And they were paid, I believe, there was 3.25 million acres, and they were given $975,000.
I believe that's right. Right, so, roughly right. Right. So there was some. It wasn't just a taking, it was an actual treaty. That's still valid today in that treaty. The Osage Nation mineral rights and royalties, and why I think this is important, and we talked about it a little bit last time, but I really want to spend more time on it, is that at the top of the spectrum in terms of severance tax issues. I believe the Osage Nation is the one that really needs to be more discovery and more potentially some litigation to sort out some issues.
So in other words, it's one of the few U.S. tribes that's being taxed.
Right. There, you'll see some cases we look at, and there's cases that say you cannot tax the royalty interest of a tribe. And yet here we are with Osage Nation, and their royalty interest is being taxed, and it's 5% is the current tax on the royalty interest. And we'll look at the entire legal authority that set that up from 1906 to current, and see if maybe that's subject to some of these issues we're talking about. So keeping on then, this Section 18, 1153 Major Crimes Act. Again, for severance tax purposes, you might wonder why we're talking about Major Crimes Act. But again, it relates to jurisdiction of the state's rights to jurisdiction in Indian country. And so, just to be clear, because I think there was I got a question after the last one. If you and I, Chuck, are in Indian country, so we go to Tulsa, Oklahoma, which you often do, and we go together, and let's say there's a mistaken identity, and we are charged with murder, for the crime of murder, that with me and you both. Well, the state would not be able to charge me with that crime. They don't have jurisdiction over me in Indian country, which is the Creek Nation in Tulsa, Oklahoma. They would have jurisdiction over you. And it is this very statute right here, 181153, and I need to advance that, I'm sorry. 18, Section 1153, the Major Crimes Act, that makes that case. So the federal government, the United States government, retained full jurisdiction over these major crimes committed by an Indian in Indian country. And me being a member of the Muskogee Creek Nation, I fit that category. You are not an Indian, correct?
No.
And you would
Swedish.
You would not commit that category. Now, a lot of Oklahomans do have a certain background of Native American ancestry, and so of course those individuals might want to apply this due to the fact that there's no death penalty with the federal, so it would be with the state. So it seems unfair, and that's one of the things that probably needs to be resolved, but nevertheless, that's exists, and it's not really subject to dispute right now. No one's litigating it. It's such a strong basis in the law, really can't be disputed. So, and again, we use that for civil jurisdiction as well. So scrolling forward there, I'm going to skip through to the Dawes Act on page 27. And this is the allotment area right here. So all of the Creek Nation and really all around the country, the lands of the Indians were being allotted from tribal ownership to individual ownership. And so this happened again, Muskogee Creek Nation. It happened with the Osage tribe, and it wasn't under the Dawes Act with the Osage tribe, but we're going to go over that a little bit.
So the big five is the 5 civilized tribes.
That's correct. Yeah. And so they rejected the Dawes Act originally, and they had the authority to do that. It wasn't forced upon them. But later, through another act, through the Curtis Act, it became upon them. So, and I think it was pressure from Congress. So if we'll just hold on, pause right there for a minute. We're going to start now with really focusing on the severance taxes. And specifically the Osage. And at the end of the slide presentation, I've gone ahead and included the entire act of April 25th, 1940. At the very end of the slides, and we'll get there. There's earlier acts that I wanted to go over just to show how this came about. So real quick, June 28th, 1906 is the act that first created leasing rights for the Osage Nation. And it's the act's kind of long because it deals with other things. It's basically their allotment act. In fact, it's titled An Act for the Division of Lands and Funds of the Osage Indians in Oklahoma Territory and for other purposes. The Section 3 of the act provides for leasing, and it's a simple sentence, and it says, leases for oil and gas and other minerals covered by the selections and divisions of land here and provided for may be made by the Osage Tribe of Indians through its tribal council with the approval of the Secretary of the Interior. So here we're beginning the process of the BIA is going to start supervising leasing oil and gas, not just for the Osage, but for all the tribes across the nation. This act is just particular to the Osage, though, and many acts are particular just to a few tribes. This one's just for the Osage. Now notice there's nothing in this act, you can take my word on it, that there's no reference to severance taxes.
Do any of these acts, even though they just reference one particular tribe, are they sort of like Supreme Court rulings where they're used as precedent for other tribes seeking?
I think that probably could be true, but with one caveat, and that's the fact that even today, there's not a lot of information exchange from one act to another. So if for instance, the Jicarilla tribe in New Mexico is arguing regarding the same types of issues, the tribe may be unaware of this act. Now their attorneys obviously can do the research and discover other acts, but you don't really see the reference in terms of carrying weight from one act to another, right, just because the tribes aren't familiar with all the acts that pertain to the 500 federally recognized tribes.
There's 576.
Yeah, it's enormous. So
39.
Yeah, so for instance, this act is not codified. If you look under the United States Code or in Oklahoma statutes, you're not going to find a reference to Osage paying severance taxes in the states. It is an act of, it's this act in 1906, amended in 1921, and amended again in 1940, that says the Osage tribe is going to pay 5% severance tax. So I want to get to that, and then I want to talk about some of those plenary issues we talked about earlier. Does the federal government have the right to do that? Okay, so again, no severance taxes discussed there. So from 1906, when this act was enacted, till 1921, the Osage tribe paid no severance taxes. There was nothing to authorize severance taxes on the tribe. So again, 1921, Act of March 3rd, 1921, Congress did enact a severance tax for the Osage Nation. And that act then was again amended by the current act, which is April 25th, 19. And that act, it's small, but it's in its entirety on the last slide of this presentation. So I think it's important just to have the entire language in there. And we're going to parcel that a little bit if we have some time. And I think it's necessary that we do that. So again, this is April 25th, 1940. So 20 years after the original enactment in 1921, approximately 20 years, where the severance taxes were set forth. So state of Oklahoma is authorized from and after the passage of this act to levy and collect the gross production act tax not to exceed the existing rate. That presented a problem right there. The existing rate in 1940 or the current existing rate. Phillips brought a lawsuit in 1975 challenging this statute, meaning that the existing rate met the existing rate in 1940 at the time it was written, and they lost. They sued the Oklahoma Tax Commission in Oklahoma Supreme Court and lost. It did not get challenged to the United States Supreme Court. So we have an Oklahoma Supreme Court decision that says existing rate there means the current existing rate. Now that is for the lessees. That's for the lessees severance tax. So if you're an oil and gas company doing business in Osage County, you're going to pay the same severance tax that you would on mine, which at this time is 7%. You know, on reading on, it says, except as otherwise provided, the gross production tax on the royalty interests of the Osage Indians shall be at the rate levied by the state, but in no event to exceed 5%. So they've capped the Osage royalty at 5%, the severance tax at 5%. Now, here's where this statute begins to border being unconstitutional or outside the scope of Congress. There's really no doubt, and it's well accepted at this point, that Congress has the right to waive immunity from taxation on behalf of the tribes. That Congress in its fiduciary capacity and its trust relationship with the tribes can waive the immunity. That's what this would be considered. This would be considered a waiver of immunity from state taxation, authorizing the state to assess the tax. And that's really for both the lessee and the lessor, but especially for the royalty side. Without this express act right here, by no means would the state of Oklahoma be able to assess that 5% tax. So is this constitutional? Is it outside the bounds? Some would call it, and as they have, this is 80-year-old statute now, a waiver of tax immunity. But if it's only waiving up to 5%, it's not a full waiver. It's a partial waiver, correct? Does it approach the possibility of being a one-sided unilateral compact with the state? Maybe it's not really a tax waiver at all. Maybe it's just an agreement to allow the state to assess 5% taxes. Probably not yet, but let's go on. This also says that this gross production tax doesn't have to be paid unless the Secretary of the Interior also doesn't say who pays it. It says there's an additional 1/5 that said some be delivered to Osage County, half for roads and bridges, and the other half for schools. You and I, as we're being assessed taxes, we can't really tell the taxing authority what to do with that tax, correct? They're going to do with it what they do with it. They can assess the taxes. We can't tell them what to do. Here in this situation, there's this express provision that half of 1%, if you read the statute, has to be spent on roads and bridges, and the other half, 1%, has to be spent on the maintenance of common schools. To me, that sounds like a compact. If you look at our casinos here in Oklahoma, they're not subject to taxation. They are subject to a compact agreement where the tribes pay approximately 6% of the total revenue to the state. And it's an agreement, and it's an exchange for exclusivity fees. So this to me looks like a one-sided compact that the tribes never agreed to. This looks like if it were just an express waiver of taxation, then you could say, okay, the states are free to charge a severance tax to the Osage on their royalties. But here's its condition. There's conditions, and it's limited to only 5%. So to me, it can't be an express waiver of tax immunity. It's some other type of agreement. There's something else there. Is it enough to say that this is outside of Congress's authority? It's certainly enough to make the argument. For instance, Congress apparently doesn't believe it has the right to execute gaming compacts on behalf of the tribes with the states. They put it on the tribes to execute those gaming compacts. So anything class 3 gaming, go ahead and do it, but have a compact with the state, and you're free to execute that. That has to be approved by the Secretary of Interior, but nevertheless, that's what that looks like to me. We'll go on. That act right there is still in effect. Hasn't been challenged to my knowledge, but I think it's ripe for challenge, depending on the outcome of the few cases we're going to look at here shortly. White Mountain Apache Tribe versus Bracker is a case that talks about the state's rights to assess taxes on Indian reservations. Not specifically a severance tax case, but it's the leading case, one of the leading cases in making that determination. In that particular case, it was the Fort Apache Timber Company had a logging company called Pine Top, and they were, cutting timber and driving them off the reservation. And the state attempted to assess a fuel tax and a roads tax to Pine Top for the amount of work they're doing in the tribe. And the Supreme Court held that was too attenuated. There was no way they were going to allow the states to assess a tax on the reservation when the state was basically providing those services, other than the fact that maybe you crossed a state highway to get to the reservation. But for all intents and purposes, all the work was done on the reservation. The state provided those services, didn't monitor the roads, didn't, so there was no reason for the state to issue a tax, and that tax was disallowed by the Supreme Court.
So is that Bracker's balancing test?
Bracker's balancing test. That's a big test, and it's still obviously good law, and one of the main cases cited in any Indian law case dealing with civil or jurisdiction purposes. Montana versus the United States, not a severance tax case, but again, one of the main rules used to determine civil jurisdiction. And it involved a tribe that sought to regulate fishing on its rivers. And this one was disallowed the other way. So the court said, no, that's too attenuated. You don't have the right to regulate non-Indians on your reservation. And there was, again, these are not bright line rules, because there's always exceptions and different fact patterns that drive the court's decision. And this one was based on some ownership to the riverbed. But again, this one went the other way. But did, as you'll see, I placed in green there, the two major rules. One being that the tribe may regulate activities of non-members if you enter into consensual relationship with the tribe. Mm-hmm. So for instance, oil and gas purposes, you're entering into a consensual relationship with the tribe. If you're drilling on their land, that's going to put you under that authority. The other exception would be if the conduct of the non-Indians exposes a threat to its economic welfare or its right to self-government. Now that rule, again, if we viewed that rule as broadly as we view the plenary rule, then there's no limits. We could say anything a non-Indian does on the reservation, if it's detrimental to the tribe, that it threatens our right to self-government. And so we could tax, we could do everything just like any state could do to any individual.
This is in 1981. Given the current Supreme Court members, who are they, and are they favorable to the tribes? Do they have any history?
Yeah, well, Justice Gorsuch is probably the biggest supporter of Indian rights that maybe has ever been on the Supreme Court. But a lot of it is political. I mean, you have justices that were appointed by Democratic presidents and justices appointed by Republican presidents. President Trump appointed 3. Justice Gorsuch, which he's very favorable to the tribes, Justice Kavanaugh, and Justice Barrett. But in terms of liberal conservative, it's in favor of the conservatives now, and you'll see some of that. There seems to be a little bit of bleed through in politics in some of these cases. But in the cases coming up, I don't think politics is going to play a role in that. I think it's going to be really court's view of the plenary power and what we'll talk about here shortly. The Indian Mineral Development Act, again, this act is silent on the issue of taxation. This could have solved it all, but it just was silent about it. Now, there was reference in the legislative history. What about severance taxes? Or can tribes assess severance taxes? Can states assess severance taxes? And it was basically deferred to the Supreme Court. It said the Supreme Court's enlightened us on this recently, and we'll let them. So the purpose, where it says to maximize economic return for the tribe, that's obviously in favor of not allowing states to assess severance taxes to the tribes, but it's not specific enough that the court's willing to rely on that alone. Okay, Merrion versus Jicarilla Apache tribe, 1982. This is the largest severance tax case in terms of allowing the tribes the right to assess severance taxes on the non-Indians. And so in this, the Jicarilla tribe, they're in the New Mexico tribes. You can see that 745,000 acres created by an executive order reservation, which is significant because there's statutes that apply to executive order reservations and statutes that apply to treaty reservations. They happen to be executive order reservation. The holding there, it's all green, you can see there, and the holding there, no cliffhangers. The tribe has inherent power to impose severance tax on petitioners' mining activities as part of its power to govern and pay for the cost of self-government. And that seems natural, right? If you got a 750,000 acre reservation and you have oil and gas companies coming in and drilling on your reservations, then why shouldn't you be able to assess the severance taxes just like the state? So in this particular situation, Merrion was an oil company, Bayless was another one, and they sued because they were already paying state severance tax. So you can imagine from the oil producer side, we don't want to pay dual taxation, we want to pay one.
Right.
So nevertheless, this was kind of a strict adherence to the law, and there was just nothing in the law that would prevent the Jicarilla from assessing severance taxes. They still are assessing severance taxes, and I think there's a good relationship at this point with the Jicarilla and the state of New Mexico and that area. But it's just a well-accepted principle now. And there are other compacts that can offset severance taxes from one to the other. So the state can give a credit and the tribe can give a credit, so that the result is you pay the same off and on the reservation. But Merrion Jicarilla, a big win for the tribe, probably. The court's continuing in this time frame, 1982. This was, again, not a severance tax case, but it's the right on the state's right to tax on reservation. And in that situation, the state had closed the only high school on the reservation. And so the tribe went about the process of rebuilding a high school. And when they did, the state assessed a gross production tax, or a gross receipts tax on the people doing the construction. That was held to, again, be too attenuated. The state's not doing enough there to support the tax, plus the fact that it's on the reservation. Again, a big win for the tribe in that regard. So that one's called Rama. So you'll hear Rama and there's Merrion. Those two cases, big wins for the tribe, big wins for their rights to assess or to not be assessed for tax.
Looks like a lot happened during the 1980s.
Yeah, and we've got some big ones coming up. So, but going on, there's Solemn versus Bartlett. Now this time we're not in a tax case, we're in a disestablishment case. Okay. And again, I know I'm going kind of fast, so just stop me if I am, but disestablishment meaning what is the reservation? Is it the original reservation or is it something much smaller now? As we said earlier, the entire east half of Oklahoma was originally reservation lands. And that's recently been found to be true. However, when I was growing up and just for the last many decades, I would assume most people in Tulsa had no idea there was a reservation. Huh. I know I didn't. I grew up there and I didn't. So, but we will see some things coming up right about this time frame that help reestablish that. So this is a disestablishment case. Solemn versus Bartlett. Bartlett was convicted of rape. He said, "You don't have jurisdiction over me because this is reservation lands." And the state said, well, the Cheyenne River Act in 1908 disposed of all that land. And the holding was, no, it may have disposed of the land, but Congress did not specifically come out and say we are disestablishing the reservation or diminishing the reservation. And the court said until they do that, then the reservation exists. So this would be basically a precursor to the McGirt case that we have in Oklahoma and the Murphy case that we talked about last time. And you'll see that's still the current law. Montana versus Blackfeet Tribe of Indians. So in that case, there's again another case about the severance tax, and the state of Montana was taxing the Blackfeet Tribe of Indians on the royalty side. And so the court took a good look at it and said the 1924 Act, which we talked about in the first part to this series, but does not authorize Montana to force its tax on leases issued under the 1938 Act. Now, this one, it really can go either way. Again, the 1924 Leasing Act authorized severance taxes. The 1938 amendment to that act was silent about it. And as we looked at briefly a minute ago, the 1982 Mineral Development Act, again, silent about it. So silence has caused the problems. And you see here we are in 1985, well after the 1924 Act, well after the 1938 Act. Parties still don't know the existing law. And it's not their fault. The law is not clear. But what this court said is the 1924 Act, it took a middle road. The 1924 Act authorizes leases, and that taxes under the leases. The 1938 Act does not. These leases are under the 1938 Act, therefore, no state taxes. Another big win for the tribes on that one.
A lot of green.
A lot of green, so good. The 80s were good. The Indian Country U.S.C. case, that's another disestablishment case, another precursor to McGirt. So many think that McGirt just came out of the blue. Here in 1987, these issues were being discussed. that the Creeks, this was the Creek Nation, recognized that their reservation had not been disestablished.
Why do you think McGirt stood out? Because it's kind of a popular subject and made the news a lot.
Well, this was a 10th Circuit case. It didn't get to the Supreme Court. Had it got to the Supreme Court, it had been binding on the entire country. This is just binding on the 10th Circuit. And just, I think the information age changes from 1987 to 2020. So a lot of people may not have even been aware of that case. Nevertheless, big case here, Cotton v. New Mexico, big win for the states. Again, we're looking at the Leasing Act on severance taxes, 1924 Act, so states can tax. 1938 Act is silent about it. 1982 Mineral Development Act, silent again. So that's the nature of why you're having a lawsuit here. Cotton Petroleum versus New Mexico. Cotton Petroleum sought this time to sue the state as opposed to the tribe. They're being assessed dual taxation. Again, it's the Jicarilla assessing the other side of the tribe's tax. So Cotton Petroleum in this situation is paying 14% severance tax as opposed to, I believe it was 6 or 8% off the reservation. One the tribe was paying 6 and the state was 8 or vice versa. But the court went through the analogy, and this time for some reasons that you see here, maybe we have time to talk about all of them, it went the other way.
15 minutes.
Okay. It went the other way, but could have just as easily cited for Cotton. And I've listened to the oral argument, and listening to the oral argument, it looks like they're going with Cotton, and the case came out the other way. But so this is the major case that's carries the weight for the fact that states can tax the lessee.
That'll be on the next slide.
Yeah, states can. Now, states doesn't have anything to do with the royalty interest, but in terms of the lessee, the non-Indian lessee, in this case, Cotton Petroleum, states have the right to assess a tax against that interest. And honestly, that case deserves way more time than we're affording it today, but there's some notes there on it. And again, if anybody's interested, that is the major case regarding.
We can come back to it right time, and
sure.
You're doing pretty good.
Okay. Continuing on then, this case is called Yakima, and this is the one I call the bipolar case. And it's a tax case, not a severance tax case, but a land case. And in this case, the court wanted to find the ground. Does the state have the right to tax this Indian land or not? So they found both. On one hand, they found the ad valorem taxes are good. And that might be on the next slide. And on the other hand, they found the taxes on the sales are invalid. So the ad valorem taxes on the Indian land, that's okay. The sales tax on the land, not okay, invalidated. And you see the reasoning that it provides there. I mean, honestly, it's a little bit comical. They say the General Allotment Act authorizes taxation of land, not taxation with respect to land, or not taxation of transactions involving land, or not taxations based on the value of land, just taxation of the land. So I think this is really one where they just wanted to come up with a remedy and went both ways. I don't know. But anyway, that's so it's red and green on that one. We go to, and these are all major cases here. So going over them fast, they're super easy to find and discuss and read up on. There's lots of information on every one of these cases. Atkinson versus Shirley. Okay, so this was a situation where the Navajo had a hotel, but it was just barely on the reservation. And so most of the guests were not Indian. They were just traveling through, and nevertheless, the Navajo were charging the hotel tax on it, and that was invalidated in this particular case. So a detriment to the tribe's right to impose taxes on non-Indians, even when it's on the reservation lands. Had it been well within the boundaries of the reservation, it probably would have made a difference. This was so close to being off reservation that the court went the other way. But just that reasoning right there tells you there's not good law to make that determination, because they're making it fact specific based on things that aren't law. There's no law about how close you have to be to reservation. So they're basing it off policy, not off law. And to me, that's a bad thing. Doesn't make good for precedent, which is why so many cases are going both ways. So Nevada v. Hicks, another one that went against the tribe. In this situation, Hicks was suspected of hunting some bighorn sheep, and so this game ranger came onto his property to look for them, did not find them. The record doesn't indicate whether he actually did it or not. All it indicates is they weren't found. I think on 2 occasions this was done. So Hicks sued on, illegal search and seizure, and the court did not hear this. Said you don't have the authority to sue in tribal court. You can do it in the state court or federal court, but he tried to do it in tribal court, and the state said our police power is not subject to tribal courts in situations where the tort was off reservation, suspected tort, because again, they never found this head of this bighorn sheep, but they thought he had done it. So that the policeman had the authority to come on reservation to look for it. So again, there's a distinction made, fact specific, but not legally, probably not good for precedent. So, but in that particular situation, bad for the tribes. So lost that one. Moving on, Mountain Ute Tribe versus Rodriguez. And this is a tax case. Now it's only a federal circuit case. Most of these others I'm pointing out Supreme Court cases. But this is a federal case, appellate case, 10th Circuit case. So it's binds us here in Oklahoma, wouldn't bind outside of the 10th Circuit. And it ruled against the tribes. And these 3 things here, saying the regulatory scheme is not exclusive, although it is indeed extensive. So you're weighing how much the federal government is involved in the work of the tribe when you look at whether the states can assess taxes against the tribe. Here again, it said the economic burden, just like in cotton petroleum, falls on the non-Indian operators, not the tribe. So it takes that into account. If the tribe's not going to suffer the economic detriment, then it's government's more inclined to allow the states to assess taxes. And the last one is that the state had asserted a sufficient justification for imposing the taxes. So that was another one. You won't see that one too much, but that one is a 10th Circuit case, so I included that. Nebraska versus Parker. That's a disestablishment case. So again, we're talking about Indian lands. And again, just to backtrack, when we're talking about taxes, we need to know what lands we're on. Are we on a reservation? Or are we on state land? So these disestablishment cases are directly related to the tax cases. This one's a disestablishment case. The tribe tried to ban the sale of alcohol in the town of Parker, small town of Parker, Nebraska. The state of Nebraska obviously didn't like that. Again, the tribe said, well, that's part of the reservation. And the court went through the analysis and determined, again, unless Congress has specifically said these lands are no longer reservation lands, then the reservation still exists. So in this situation, that reservation had not been disestablished or held in favor of the tribe on that one. And that one, again, is another one that was authority for McGirt and for Murphy that we'll see here in a bit. Oklahoma versus Castro-Huerta. This is a disestablishment case. Again, why it's important for tax purposes to know where the jurisdiction lies. Just to give you background on Castro-Huerta, it's a bad situation. Castro-Huerta is a non-Indian living outside of Tulsa on reservation lands as established by McGirt, after McGirt, okay? So he was charged with child endangerment. They found his 5-year-old daughter, I think stepdaughter, in bed. She had cerebral palsy and was covered in lice and excrement and every as a vile thing as you could be. So the child abuse is not a situation where there's possibly he was innocent. This person was guilty. But after McGirt, of course, his claim is the state doesn't have jurisdiction over it. under the General Crimes Act, which is 281152. We looked at it a little bit just for time. I won't flip back to it, but it's there. And it says that the federal government is going to retain jurisdiction. The laws of the federal government apply to Indian country. Well, the way the court interpreted this is that jurisdiction didn't go to the federal government. Only the laws of the federal government apply, so that the state did have jurisdiction over him. So this was a non-Indian committing a crime against an Indian. So the tribe's argument is we have jurisdiction, or at least the federal government has jurisdiction on our behalf in their trust responsibility over this individual, because we have obviously a interest in preserving the health of our citizens. But the court went the other way. And again, this is post McGirt. So is this case just an attempt by the court to neutralize McGirt? It's a valid question. Let's put it that way. So this court, I think a lot of people said, was the most harmful case to Indian tribes in terms of diminishing their jurisdiction, sovereignty, authority, everything. So in other words, McGirt creates this reservation that's half of eastern Oklahoma, 5 tribes reservations, and Castro-Huerta says it doesn't matter, where the state's going to retain jurisdiction. That's not the legal analysis, but that's the effect of what happened. So what's the point of McGirt if the state's going to retain jurisdiction over the land? So this case went against every case law precedent imaginable and still found that the states had jurisdiction on that case. And again, probably just to neutralize the McGirt a little bit, because there were some problems with McGirt after McGirt. Then there were a lot of cases that were going unpunished by the state. They didn't have authority. The federal government brought in extra agents, extra prosecutors to handle it. Honestly, you get both sides of the story. The federal government says there's not that big an issue. The state, if you listen to Governor Stitt, for instance, it's an enormous issue. So like everything else, the truth's somewhere in between. I guess the last case we'll look at here is Holland versus Bracker. This one's neither a disestablishment case nor a tax case. I call it just a Title 25 case. Title 25 of the United States Code, covering all Indians. This is the Indian Child Welfare Act, and Bracker is a couple that sought to adopt an Indian child. They had fostered the child, I think, for 3 or 4 years. And when the adoption was, tried to finalize adoption, they were told, no, under the third preference of the act, the child has to go to a member of an Indian tribe. That's under the third preference. And they weren't Indian. Holland being the Secretary of Interior, not for name purposes only. So they brought a suit. This is in Texas. And they originally won at the district court level, found that the statute's unconstitutional based on race and some of these other things you can read here. It was appealed, and on appeal, part of it were reversed, some parts weren't reversed. And then it went to an en banc appeal, which is all of the judges in the Fifth Circuit sitting on the bench to decide this, 16 judges, and it went 8-8. So again, these issues are not easy issues. Again, and the reason why they're not easy is because from decades and centuries past, we haven't set good legal rules to determine what's the scope of Congress's authority, as we were talking about earlier. What is the scope of laws? How much does it involve? Well, government so defends this suit at the Supreme Court level. It's been heard and is awaiting to be issued. So in June, it should come out. But the federal government's position is Congress can do whatever it wants under the Indian Commerce Clause and under the plenary power. And the Indian Child Welfare Act is not outside of that. That's the federal government's position. Bracker, along with the state of Texas, says, no, that's based on race. You couldn't, for instance, have a Child Welfare Act that says a Asian baby has to go to an Asian couple or a white baby has to go to a white couple. All those would be deemed unconstitutional. And so it's been heard. we're awaiting review. And the question is now squarely before the court, how much authority does Congress have? Does Congress have so much authority under the plenary power and under the Commerce Clause that they can make an act here, the Indian Child Welfare Act? And I'm not saying whether it's constitutional or not. I'm saying if the holding and the evidence is there that yes, it violates these things. It violates anti-commandeering of the 10th Amendment by making Texas go through these things, and equal protection, substantive process. All that it doesn't matter because Congress had a purpose, and under the Commerce Clause and plenary power, they have the right to exercise that. That would keep it where it is. They could go the other way and say, you're right, Texas, we don't have that authority. And now when you don't, each tribe might come back and say, we would take a look at this statute again. Because if you didn't have the right to do it, then is this statute unconstitutional less? Because we're being treated different. So some of the arguments I said earlier may seem like they were over the top and out of bounds, but compared with this, they're really the same things in different areas of law and up there.
I do have a couple of follow-up questions, just kind of in a summary. I mean, what do you think the current state of Oklahoma and the tribes is today? What's the relationship?
It was great from 2004 when we signed the gaming compact. The gaming brings, it's a $3 billion plus business in Oklahoma. So imagine the revenue and good it does for the tribe. So from 2004 when we signed that, for 15 years, the relationship was great with the tribes. When it came time expiration 2019, it came to renew. Governor Stitt wanted to renegotiate that, and it did not get renegotiated under the terms of the contract because we have horse racing in Oklahoma. There is no longer a need for exclusivity fees, so the gaming compact renewed for another 15 years under the old. But nevertheless, it's basically 6% of the revenue, which is about $180 million on a tax base. It's not taxes, it's an exclusivity fee, but that goes to the state.
How much was that again?
About $180 million annually
to the state of Oklahoma.
Roughly 6% of $3.2 billion. But and that is only going to go up. It's going up year after year after year after year. The Chickasaws are leading the way on that between the five tribes. Seminoles not really involved in that, but Chickasaw, Cherokee, Choctaw Creek, Chickasaws kicking in 70 million of that 170 million.
Yeah, just a tremendous revenue source, no doubt. Thanks again for joining us. Again, Oliva Gibbs does this monthly. We have webinars and seminars, and they're free. You can check out future webinars on our website, and if you missed any of the past ones, you can also view those. We have offices in Houston, Oklahoma City, Lafayette, Louisiana, and Columbus, Ohio, and we're approaching about 40 oil and gas attorneys, and we're looking to place more in our offices. So if you know any amazing attorneys, or if you are an amazing attorney, we'd love to hear from you. So again, thank you for joining us, and you can get CLE credits for Oklahoma, Texas, and some landman credits. Thank you again, and we'll see you next time.
Thank you.